Good afternoon, everyone. I'm Terry Gerstein, and I'm really excited to be here with all of you today to talk about danger and opportunity in relation to labor and workers' rights. So just the initial framing, this is a tough time for labor and for workers, as for so many people and issues that we care about. And it's also an exciting time in many ways with a lot of movement and energy and innovation. At the Supreme Court, we have had a run of bad decisions, and we have another, concerning decision that is pending now. We've had decisions kneecapping workers' rights to organize and to exercise their collective power to improve working conditions. We also have some stagnation in terms of legislation with the minimum wage the same as it was 14 years ago, when we still don't have paid sick leave. But at the same time, there's been a huge upsurge in organizing, including at some of the household names, really well-known major national corporations. There's been a lot more attention to workers' rights nationally from everyone, policymakers, the media, just the general public. We still don't have our own TV show yet, but sometime we'll get one, I hope. And there's also been a lot of exciting and innovative developments at the state and local level. And so we're going to talk about both the we'll start with the gloomy part of the conversation, and then we'll talk about some of the positive developments. So really brief introduction to the panelists. I should introduce myself. I direct a project on state and local enforcement at the Harvard Center for Labor and a Just Economy, and for many years I enforced minimum wage and other labor standards laws in New York State, including at the state AG's office, where I was the labor bureau chief. But our panelists are amazing. You should read their bios thoroughly, but I'm going to give a super abbreviated version in the interest of time. Kate Andreas is a professor at Columbia Law School. She teaches constitutional, labor, and administrative law and studies and writes about those topics. And before law school, she was an organizer for the Service Employees International Union, SEIU. Next to her is Dorian Warren, who is the president of Community Change, the co-chair of the Economic Security Project. He's a progressive scholar, organizer, and he's a frequent media commentator on many different issues. There's so much in his bio. I asked him how to introduce him, and he said a political scientist and community organizer, and I got worried I was going to call him a political organizer and community scientist. And we thought that a community scientist sounded like a really cool thing, but anyway. So next we have Cesar Rosado, who is a professor at the Iowa College of Law. He teaches contracts and labor and employment law, and prior to becoming a professor, he represented unions and workers in New York City. And then directly to my left is Robert Shore, who's an associate general counsel at SEIU, and he advises SEIU's Fight for 15 in a Union campaign, as well as the State Power campaign. So that is who we have with us today. And we're going to start out with a question, a framing question to Kate about, it's sort of one of these like speed speaking kind of things, like in 5 minutes or less, tell us how the Supreme Court has been so bad for workers in recent years, some of the recent decisions that are adverse to workers and what's coming up, and also why does this matter? Why is labor important and labor rights important both for workers themselves as well as for democracy and democratic participation?
Great. Well, first of all, thank you so much for having us. Thanks to ACS. And so I get to be gloomy, I guess. I'm going to jump back and talk not only about how bad the Supreme Court has been, but how bad the law is more broadly, and how the Supreme Court's recent developments kind of fit into that. So as many of you probably know, labor union membership is at its lowest point since the 1930s. Only about 6% of private sector employees are in unions, and only about 10% when you add in the public sector. Our labor law fundamentally fails workers. I think that has to be where we start from. And that's been true even before the recent spate of anti-worker Supreme Court decisions. So as a formal matter, labor law protects the right to organize, to strike, to bargain collectively. But in practice, it is really hard for workers to exercise any of those rights. First of all, many workers are excluded from protection under the labor law. Agricultural workers, domestic workers, and workers classified as independent contractors, the vast majority of whom in those sectors are women and people of color. Even for those employees who are covered by the law, it's very hard to organize. There are almost no penalties for coercing workers who try to organize or for refusing to bargain. And employers are permitted under the law to do a lot to intimidate workers into not exercising their rights. Third, strikes and protests are not effectively protected. Employers can permanently replace workers who go on strike. There's no right to engage in secondary strikes, meaning strikes against a related employer who's not your own employer. And then finally, our labor law is just not set up in a way that matches our economy. So workers have to organize on a shop-by-shop basis, and they have the right to organize with their direct employer, but that's not how our economy is organized. We have massive corporations who are really fissured and have lots of levels of subcontracting, and we don't have a labor law system that matches that. So these problems date all the way back to when our labor law was originally written, and then in particular to 1947 when it was amended to be more anti-worker. But they have been even, the problems have become more acute since the 1980s, when employers began aggressively fighting unions and routinely violating the law and restructuring themselves in ways that make the law less effective. And then, more recently, in the last few years, the Supreme Court has made things worse in a series of cases and threatens to do so even more in potentially in upcoming cases. So to highlight just some of the big ones, in Janus in 2018, the court held that all public sector workplaces have to be open shop, meaning states, state government employers or public sector employers and unions cannot agree through a contract to have all workers who are covered by a contract pay dues or pay fees to the union, even though all workers get the benefit of the union. So it creates a really deep free rider problem. And that case was the product of a multi-year campaign by anti-union forces and anti-worker forces trying to weaken workers' political power. In Epic Systems, also in 2018, the Supreme Court held that employers can require workers to waive their rights under labor law to proceed collectively in court through mandatory arbitration agreements. And then in Cedar Point Nursery in 2021, the court held that it constitutes a takings in violation of the Fifth Amendment for a state to require an employer to grant unions limited access to property to talk to workers. So in California, under the agricultural law, organizers had the right to enter farms just to talk to workers about organizing the union. The Supreme Court said that was a taking, violated. And now, in a pending case, Glacier Northwest, the court is considering whether a state tort law action can be brought against a union that engaged in a strike, despite preemption principles. So depending on how the court ends up deciding that case, it could cripple or really limit the right to strike by allowing states to impose severe tort damages. Or it could be a modest opinion. We'll see which way they go. But even more concerning, perhaps, is the court's assault on the administrative state, which could really eviscerate the power of the NLRB to protect workers' rights. So I see that my time's almost up, so I won't go into any detail on all of that, but I'm going to close with just saying why we should care, why this is something that we should be deeply worried about. For one, the lack of unions really matters for workers' experience on the job, right? It means that most people spend their lives living under essentially authoritarian regimes where they have few rights. Two, unions are critical for raising wages and for lowering economic inequality. So the decline of unions is one of the factors that help explain the really terrible rise in economic inequality in our society. But third, and this goes to Terry's kind of opening question, unions promote democracy and guard against authoritarianism. And that obviously is a critical problem facing us at this moment. Unions strengthen democracy in several ways. First, they enable workers to practice democracy on a daily basis at work. Second, there's lots of evidence that show that they increase rates of political participation by workers. So workers who are in unions vote at higher rates, they protest at higher rates, they sign petitions, they speak with legislators, they do all of that more than workers who are not in unions. And third, and related to that, they produce more representative government, because through that aggregated political power, government, they serve as a countervailing force to organize business. Finally, and it's something that I think is less talked about, or less known, but there's, is that they serve as a bulwark against the conditions on which ethno-nationalism prey, because they provide one of the few opportunities for people of different backgrounds to come together and to act collectively in service of a common goal. So they bring people of different ethnic, racial, and political backgrounds together, and have been shown as a product of that to reduce social divisions and to serve as a bulwark against rising ethno-nationalism and authoritarianism. So undoubtedly not all unions serve that function, and unions don't always serve that function equally well, but they have a particular capacity to do so. So I think at this moment in our country, when we're facing rampant, really rising inequality, but also a real threat to democracy, the problem of declining unions and lack of decent labor law is one that we should all be deeply concerned about.
Thank you, Kate. And on that point of democracy, I think it's noteworthy when you think about dictatorships through history, like Pinochet in Chile, or the Nazis. Like, they both went after trade unionists, and that is sort of one indication of the anti-tyranny, like anti-authoritarian power that unions actually represent. It's like collective power of working people, and even though unions are not as strong in the US as they could be, they're still one of the only major institutional sources of collective human power against corporate power. And the statistic, I just want to share the statistic, that 6% of private sector workers currently are in unions, around 6%, but when they do surveys of private sector workers, the answers are that 50% say they'd like to be in a union if they could, and 70% of people in separate surveys say they support or approve of unions. So there's like a real schism that just shows what Kate was saying about the deficiencies of our current law. So now, before we get into the exciting things at the state and local level, I'll say the first CLE code, which I was supposed to say when we started, which is evergreen. So now moving to the things that are happening at the state and local level, and if you can also, when you give your comments, think a little bit about what role lawyers and law students can play in this. We'll have Rob first answer what are some, so with regard to the things that are happening that are positive in workers' rights, there are, obviously our country has very different landscapes in different states and localities, and some are really amenable to worker issues and some are really hostile. So we'll start with the places that are more favorable landscapes and ecosystems. So Rob, if you could talk about some positive developments for workers' rights at the state or local level.
Yeah, so I hope for this to be a little bit more positive than Kate's, but one area that we've seen some really strong laws come up are California. Obviously, the Fast Recovery Act in California is a workplace standards board for the more than 500,000 fast food workers in California. The board will be able to set wages and working conditions, and it'll be made up of representatives of workers, of the industry, and of government. So it's a tripartite board, which is a theme of the boards that I'm going to talk about. It can handle things like health and safety, violence and security, discrimination, harassment, training, and other things like hours. The training piece is extremely important in this law because it will train on its law, on the things they develop, but also it'll train on the existing labor laws. And as we've seen, those laws are not being enforced and workers do not know about them. And in fact, over the last 3 years that SEIU and our team in California have been working, particularly in the pandemic, we filed over 250 complaints that deal with wage theft, OSHA complaints, various wage and hour violations for fast food workers alone. I'm only talking in the fast food industry. They deal with violence on a daily basis. Workers get threatened both by managers, by customers, by people who come in, and the industry is basically a poverty industry. In fact, Fast food workers are the largest segment of workers in poverty in California. 1 in 17 homeless people is a fast food worker in California. So there is this void that nobody is enforcing, and so this standards board would do just that. In Minnesota, they also have passed actually it was this past Wednesday, it has yet to be signed by the governor, but a nursing home workforce standards board was passed in Minnesota that also will have this important training mechanism. It will make recommendations on health and safety. It could set minimum standards for wages and benefits like sick leave, which is a huge, huge thing for nursing home workers. That also is tripartite. And it actually gives the nursing home workers a civil action if they see a violation of the standards that are developed. Another standards board that has recently been passed is in Colorado. This is for home care workers, and this one is particularly interesting because while it has both the tripartite, it actually has a fourth group that sits on the board, and that's the patient receiving the care, or their representative. So that board as well that's a bigger one that has 15 members, and it too would set standards around wages and other aspects of working conditions for home care workers. The last place that I wanted to talk about was Michigan, where we have yet to, there is a standards board in Detroit that passed a couple of years ago. The standards board lacks some teeth because Detroit has been hamstruck by restrictions on home rule, which has already been proposed in the legislature there to repeal the restrictions on home rule, giving the cities throughout Michigan the right to set their own labor standards. And this board that's already been developed in Detroit would then be able to make recommendations to the local government, and the government can implement them for city workers or workers in the city of Detroit.
Thank you. And all of that, just to frame it, all of that is just really a big evolution from, to have workers and employers and a public member of the board themselves deciding what the laws are going to be and the rules in relation to that industry, as opposed to like the legislature making, for people who aren't familiar with this tripartite kind of model, it's very new in the US, the idea of instead of the legislature making broadly applicable laws, having workers in an industry have an actual direct voice in setting the laws. Kate?
Also, just to clarify one thing, I mean, the question might arise if you're listening to this, like, why doesn't California just actually create unions for all, or collective bargaining rights for all, instead of these standards boards? The reason is that federal labor law preempts states from creating local labor collective bargaining law that applies to workers who are covered by the NLRA. But what states can do is create these kinds of employment standards boards that give workers a role in setting standards.
Thank you. Cesar, do you want to share some thoughts on what you have been working on and talk about Chicago and other exciting places?
Yeah. So hi, my name is Cesar Rosado, and I teach law, but I'm also a card-carrying sociologist, as I say. So I worked 12 years in Chicago, and while I was there, I worked 2 years at the Worker Center. These are community groups that represent workers' interests, workers generally speaking as advocates and sometimes in workplace matters. And so I'm writing a book about how, these little tiny things called worker centers with no money and no members and no dues and are actually providing significant rights to workers, not only in Chicago but across the country. And so, the last count that we have nationally is over 90 state and local laws protecting workers, be it protections against wage theft, that is when employers don't pay their workers under the law, or minimum wage provisions that exceed federal standards, right, at both city and state levels. Also, we have seen paid sick leave, fair scheduling, meaning employers need to tell workers beforehand, a week or so beforehand, what their schedule is going to be, and not tell them the day before. domestic workers Bill of Rights. That is, believe it or not, domestic workers have been excluded from our main labor and employment laws, and so there has been a movement now for over a decade to kind of incorporate domestic workers into just the basic labor rights, the thin, not very strong rights that we have, but at least provide those to domestic workers. And so I was with this worker center in Chicago that worked on all of these measures. And what was interesting about this worker center is that a lot of the local ordinances that were passed in Chicago providing these rights eventually were passed with almost no opposition whatsoever from city council, right? There might have been one or two people that might have abstained or voted against, but it's I thought it was fascinating that this group was with 7 staff members and a budget of $400,000 a year was able to do this. And what I've been finding out is that they are able to really create coalitions in cities where they have some leverage that are quite powerful, right? So if you're attached to churches, if you're attached to neighborhood organizations, immigrant rights groups, race equity groups, right? There is a whole ecology of movements and groups in a city like Chicago, and you put them together, you can actually do a lot of things. But the other thing that I found out is that a lot of the aldermen, the city council people who voted for many of these measures, got there because, for the past 20 years, big unions like SCIU have been actually trying to put people in city council that would be okay with these types of laws. About 15 years ago, there was an attempt to regulate big box retailers, and that failed. And because of that, the SCIU really worked hard on putting new people in city council. So these are some of the local things. Other places have similar things going on. As I said, at least 90 of these laws are out there right now.
Cesar, can you also talk about the new mayor of Chicago for a second?
I will too, yeah.
Okay, so we'll leave that for Dorian then. And one thing I'll add also to what Cesar said is that some of these worker centers have been able to get local labor offices created and established in their city, so that then there's a local enforcement agency at the city level.
I mean, and the great thing about the Chicago office is that since the worker center actually sort of basically drew up the whole plan for it, the office actually collaborates with the worker center, goes to the worker center's office. There they meet the workers. They know where employers are not paying the workers correctly or harassing workers or whatnot, and create plans to enforce the law in that way. So we're doing what we call co-enforcement in that sense.
Thanks, Cesar. Dorian.
Well, I can't help myself. I was an organizer on that big box living wage campaign in 2006 that lost. It was the first and only veto of Mayor Daley in his long-standing years in office. But having said that, what's exciting about Chicago, I just came back from inauguration on Monday. Out of those losses, and especially 10 years ago in terms of the closing of public schools, both SEIU and the Chicago Teachers Union have really been building infrastructure. And so it's not an accident that the new mayor of the city is a former teacher and former organizer with the Chicago Teachers Union. And it's really, I will say, the progressive bloc of the labor movement that has a new day in the city of Chicago, and there's a lot of excitement right now. We can talk more about that later. So I was gonna do what I'm not supposed to do and not exactly answer your question about
That's
state
fine.
and local, because I actually wanna come back to federal for a minute, but then talk about the implications for state and local. And what I mean by that is, in this town, the last 2 years, there are 4 big bills that have come out of Congress and the White House: American Rescue Plan, Bipartisan Infrastructure Law, Inflation Reduction Act, and the CHIPS and Science Act. And I raise those with their implications for state and local because we already have a victory I'm going to talk about in a few minutes in the South, leveraging one of these acts. But the punchline here is, and this is maybe to answer the question of what help is needed, there are some levers and some rules at the federal level that need help with interpretation for organizers on the ground in terms of organizing workplaces. So, to give you an example here, last week, the week before, the United Steelworkers won the first union election at a factory receiving major funding under some of this new legislation. and essentially creating a new union beachhead in the South. So 1,400 member bargaining unit at the Bluebird factory in Georgia. There was a New York Times piece about this. It's a factory that builds electric school buses. And frankly, it was because of the rules under one of these new pieces of legislation that prevented federal money being used for union busting, as well as provided some other levers, some rules from the EPA in particular, allow the union to file some complaints, to file ULPs, to file environmental protection violations that created the enabling conditions for this victory. And so the punchline here is, I think, how do we think about these new federal investments in states as enabling new organizing, and particularly in southern states, which we know are going to receive a massive influx of federal dollars, and are places where those are places to build the political power to shift the national dynamics around labor law reform that is necessary. So there's an exciting opportunity related from federal legislation, and particularly spending, in states that I think if unions, and frankly from the community organizing side as well, if we can leverage these opportunities, can shift the national political dynamics as well.
Thank you, Dorian. Kate, do you want to share your thoughts on a few of the positive things happening in favorable environments?
Yeah, so I think the things that folks have highlighted already are really key. There's also been a movement over the last 10 years or so to enact new employment legislation in states and localities. And it's employment legislation, but it's largely driven by worker organizing, by worker centers and by unions. And so things like the Fight for 15, which raised the minimum wage in states and cities across the country. One example, pretty well known, also new scheduling laws that give workers control over scheduling. Laws that aim to try to get at the problem of algorithmic management of workers. Right? So Amazon, for example, tracks workers' every move. So anytime they stop and talk to a coworker or go to the bathroom, it gets tracked. And that can, if you do that too many times during the day, can lead to discipline. So using state and local power to try to get at the really horrendous, undignified conditions that workers face at work. Why pass those laws instead of laws that would really give workers the right to organize unions? Because of the legal regime which allows that kind of legislation and not labor law reform at the local and state level. Another example is Just Cause, which for example, in New York, a place where that has passed is restaurant workers, applies to fast food workers in New York City. A few years ago, the city council passed a law that gives fast food workers just cause rights, so that it's an industry where workers are often terminated unfairly, work on really unfair conditions, and the city extended to them the right not to be fired without just cause. That has been challenged in court by the restaurant industry and the Chamber of Commerce, and the oral argument was actually yesterday in the Second Circuit, raising the question of whether that law is preempted, and also whether it violates the Constitution, whether it violates the Dormant Commerce Clause. So with all of these endeavors, you see the Chamber of Commerce and other business organizations mounting legal challenges, arguing that the laws are preempted, or the efforts at the local and state level are preempted, or that they violate the Constitution. So lots of room for lawyering, right, in response to defend these kinds of initiatives, and also to think about how to create them in ways that can survive attack.
One thing that's also interesting, when these laws get passed at the local level, like paid sick leave laws, often if it's passed in a sort of very progressive jurisdiction, once it's been in effect for a year or two, you have proof of concept, and then that kind of eases the way for it to be passed in other localities or in states. And so, like, there was a study about New York City's paid sick leave law, like 3 or 4 years later, and the title of the study was, about employers' experience with it, and the title of the study was "No Big Deal," which is that, like, there's all of these, like, penny sky is falling predictions when workers' rights are expanded, but then once you have, even in one jurisdiction, once you have sort of, evidence that, life went on, it's really helpful in sort of deflating that opposition. And Dorian, also what you were saying about contracting as well. I mean, I think that's those contracting powers are something that people are really talking about a lot in labor spaces, and sort of so many companies are government contractors, and that's an enormous source of leverage that the federal government has a little more leeway than states and localities, but still. So what about places, I mean, Cesar, I don't know if you want to go first. You live in Iowa, so maybe you can speak from the heartland. Do you
Yeah,
wanna,
it's tougher in places like Iowa. So, you know, the story I told about Chicago is a story about all of these movements, groups, worker centers, unions, progressive aldermen, et cetera, right? And so there's a lot for you to, you know, with who you can work with, right? You go to Iowa, and you have, you know, a supermajority Republican legislature. You have almost no unions. You have very, very few groups of any sort. And so your allies, who you can work with to, you know, for progressive, you know, legal reform is much more limited, right? And so, and in fact, so you know, Iowa City, where I live, where the University of Iowa is located, passed a local ordinance a few years ago so that businesses pay their workers $15 an hour. Legislature comes in and say, well, no, you can't do that. We're going to, you know, veto that or something, right? So we've seen that happen. In fact, in some of these contracting situations, the legislature is also saying that, you know, Iowa City or Johnson County can't really kind of bid in certain kinds of things if they're going to be favoring unions or something like that. It's an issue that is also hurting. So what happens in a place like Iowa City? So, you know, so you look for the allies that you can find. And for example, activists are trying to combat wage theft, right? They can't get an anti-wage theft ordinance like Chicago has, where if you find someone committing wage theft, you can revoke their business license. That would be great. We don't have that. So they're collaborating, the activists are collaborating with insurance fraud, for the Division of Insurance Fraud, which looks at who is sort of cheating in their not paying basically certain kinds of contributions to workers' unemployment insurance, for example, right? If you're committing wage theft and you're not paying your workers correctly, you're also committing certain kinds of unemployment insurance fraud. And so they're going through that channel to get at the so-called wage thieves, right? And make them sometimes even face kind of criminal sanctions. But it's that kind of thing, sort of behind the scenes with these kind of cops we don't really know too much about, and that generates sometimes some controversy because some of your allies who, you know, don't like police, don't like the criminal justice system, they think that's too controversial for you to sort of ally yourself with. But when you have no one else, right, those kinds of folks are actually quite effective to help you. We do, so that's one option, is just use traditional law enforcement. During the midst of the pandemic, when there were all these stories coming out that there was a lot of infections going on in the meatpacking places in Iowa, the Department of Labor did not want to investigate, not federal, not local, not anyone, right? And so a community group of Latino residents of that county contacted the sheriff, who was a Democrat. And so he knocked on the meatpacking plant. He said, "Can I just, look around?" They said yes. He looked around. He found horrible situation. He contacted the news, and that became national news, right? So that was, a great way of using traditional police with community organizations to try to improve workers' rights in that sense. And so, so again, you kind of scout out who might be your allies, and you work with the folks that can work with you.
Thanks, Cesar. And just to add on to that, one of the projects that I've been working on is trying to get more district attorneys and criminal prosecutors involved in bringing wage theft and workplace fatality and other cases. And in fact, in Polk County, Iowa, where Des Moines is, the DA is very progressive, and she's really interested in starting like a worker protection unit. And so this is where there are possibilities within, DAs, for example, are generally independently elected people. And so you know, they have a lot of leeway. And just to put a name also to this issue of the states preempting local laws, there's a term called abusive state preemption, which is when localities try to pass minimum wage or paid sick leave or other kind of laws that advance people's rights, and when the state sort of steps in and preempts them from doing that. And usually there's also a racial element in that you have cities that are majority people of color, black-led cities, and then the predominantly white gerrymandered state legislature comes in and prevents them from doing that. So abusive state preemption is the big challenge that a lot of localities are dealing with in these hostile environments. Dorian, do you want to talk a little bit about positive things that are, you know, worker innovations or organizing innovations at the state and local level in some of these more challenging contexts? Or do you want to take a pass?
Well, I was stuck on the abusive preemption point, which I didn't know how to respond to, but maybe I'll just make a small point, Terry, on some of what everyone's talked about, and particularly Robert, when winning, and you too, Kate. You too, sorry. I guess I want to make a point on how where we're able to win victories around wage theft, or in terms of legislation, or scheduling ordinances, in places that are somewhat friendly. I think how you do it matters. In the sense of, so I can say this because I'm the non-lawyer here, we can't like totally litigate our way to better labor standards, but so that's one piece of the strategy. The other piece is like, how do you empower workers and how do they see themselves in the story of the victory to create the feedback loop for future organizing, which is really the point I want to make about how are we leveraging these local victories or these state level victories and creating fundamental power, worker power, which translates into political power, which then in a long causal chain can ratchet up, right, to some national political power for national labor law reform.
Thank you. Rob, do you want to share some thoughts?
Yeah, well, so based on what you said, I'm switching the order of how I was going to talk, but I think in the South, it's obviously extremely difficult to organize, but something that recently SEIU has been working on is kind of a new form of union, the Union of Southern Service Workers, which is not a traditional labor union where you sign people up, they submit a cards, and we go through the NLRB election process and all that. The Union of Southern Service Workers is where the worker themselves are a member, and no matter where they go, whatever low-wage job that they have, the union goes with them. They can organize their coworkers for individual fights at their restaurant or store, or they go from a McDonald's to a Walmart. They can organize there for better working conditions individually at that location. So it's yet to be seen how this will work. It's brand new, but I think it's worth pointing out as an innovative way that we're trying to organize in the South in low-wage work, where we're not going to get the same laws that we talked about earlier. Another area that I think is worth pointing, another area I'd like to highlight is in Wisconsin, where under Scott Walker, things were decimated and labor laws were basically, workers were written out of the laws. We've worked really hard to get the current governor elected and then reelected, and now he has the opportunity to appoint the Wisconsin Employment Relations Commission chair, who serves an 8-year term. That chair oversees the enforcement of the state labor laws for state and municipal employees. Now, obviously, they can't change the laws that the legislature has passed, but it is possible to look creatively at those restrictions and at those laws, and it is his job or her job to inform the state agencies about what they can and cannot do. So that's an opportunity there for somebody to come in and potentially creatively look at the laws and look at the restrictions and possibly do something that maybe was unexpected. Another thing in Wisconsin that I also thought was pretty innovative was in Dane County, which is where Madison is located. They passed the Healthcare Workforce Trauma and Recovery Fund as we came out of the pandemic. That fund is for healthcare workers who have obviously worked on the front lines, to give them support and mental health help and all the things that they need that they may not be getting through their employer. So while that's not a union, it is something that workers in the industry can take advantage of. And right now, actually, we're asked, the governor has put in his budget a matching fund. Whether or not that gets through the state is a separate question.
Thank you. Kate, do you want to share some thoughts?
Yeah, I guess I would just underscore what Dorian was saying about all of these local and state initiatives that we're talking about all rely on and kind of only work and are when there's actual worker organizing that they're a part of, and all the ones that, and it's important to note that there has been an upsurge in worker organizing around the country, really across professions, and so, from low-wage work to the Hollywood writers, right, who are on strike. And it's been in red states as well as blue states. So we saw the massive red for ed strikes, which were in deep red, of teachers' unions, right, in deep red states. And in those states, in addition to what other folks have already highlighted, we've seen success with ballot initiatives, right? So kind of going around the state legislatures, but by putting labor rights on the ballot. And so, for example, in Missouri, they were able to beat back right to work. There were ballot initiatives in a number of southern states to raise the minimum wage. So ballot initiatives. The other thing that Dorian already pointed to, but is worth highlighting, is using federal levels in hostile states, federal leverage, right? So either federal money, leverage attached to federal money, or using the NLRB, as broken as it is, it does provide rights to workers who engage in concerted action, and with a very progressive, aggressive general counsel, the NLRB is doing more than it has been. So it's a resource for workers in southern states. And the other thing, I guess I would having spent many years in Michigan prior to coming to Columbia, that's a state where when I first got to Michigan, it was red, right? And now it's not. And that is a product of really good organizing by labor in alliance with racial justice movements around water justice, after the Flint poisoning, Detroit racial justice movements around unfair taxing. So labor in alliance with community justice movements and really turned the state around and pressed not only for changes on those issues, but also for anti-gerrymandering, redistricting through a commission. And so the state has really changed as a result of that organizing. So no longer a red state.
So I have a question now that is sort of a little bit of a tough question for me to contemplate, because since I spend my time focusing on state and local issues, and the question is, federal labor law is broken. We have a hostile Supreme Court in terms of, hostility to workers. So is all of the innovation we're talking about at the state and local level, is this just like tinkering around the edges, or does it have real possibility for meaningful change and advancement for workers' rights? I mean, I can start by saying I have to think it can make a difference, right? Because, the alternative, I mean, there are real people today, and like that is how you build movements, right? And if you look at the right wing, how they sort of started, small in certain, they started focusing on states and focusing on localities. But I'll open it up to all of you. Rob, do you want to start?
Yeah, I can start. Well, I think it may be tinkering, but it's not merely tinkering. I think, looking at the Fight for 15, which I work on and we've talked about a little bit, it was originally a pipe dream. Everybody thought it was outrageous, in 2012. The numbers are $150 billion for more than 26 million workers. 12 million of those are workers of color, and 18 million of them are women. And that was in the end of 2021. Since then, we've had more minimum wages go up. A ballot initiative in Nebraska last year made a $15 minimum wage there. So from my position, it is tinkering, but it makes a real difference. This is a real impact on people's lives that, without these little steps that we've taken would never have happened.
So I'm originally from Puerto Rico, and since 1942, we have a law called Ley de Madres Obreras. It's law of working mothers that provides 8 weeks of paid maternity leave to all mothers since 1942, right? So that means that for about 80 years, millions of women have had this right in Puerto Rico, their children, and their spouses who have been able to go to work and maintain a family. So I don't it's, tinkering along the margins is not something I would call any of these state and local initiatives if we go down with minimum wage and the other things that have been going on. That said, I do think that strategically we need to be arguing, stating that the reason why state and local authorities need to be doing this is because the federal government, and particularly Congress, is abdicating its duty to be doing precisely these sorts of things. We have something called the 13th Amendment that provides that workers shouldn't be living under or working under involuntary servitude. A lot of these laws are there because workers can't effectively, seriously quit their jobs and force employers to give them better benefits. They're actually in conditions that look a lot like involuntary servitude, and we could be doing lots more with the Constitution that we have and the federal government that we have, but they're not doing that, so therefore state and local has to step in.
That's a really hard question. I don't know how to answer. I guess I'd just say, and you mentioned this, Kate, too, I do think we're in a moment of incredible worker organizing, upsurge, excitement, demand. And given that, I think it requires us to be more creative and innovative in this period and experimental. With the tinkering, yes, but also thinking about the more imaginative, large-scale changes I think many of us want. And given this pending case at the court, I wonder what are some, I've been thinking a lot about what is the role of civil disobedience in this period, both in terms of worker organizing and community organizing around unjust laws. And so what are the ways, like from where I sit, we're talking to SEIU, for instance, about the Southern Service Workers Union, and what is the role of community organizing and supporting worker organizing where the union might be more vulnerable depending on what the court decides in terms of damages, right? So are there creative tactics and things we can do that will push the envelope and create a crisis to be solved around worker organizing and power?
Kate, what would your answer be to that question?
I think that it's an open question. So I agree, none of it's tinkering. It's all extraordinarily important for people. It's an open question whether or not the upsurge in organizing and the kind of tapestry of local and state initiatives are going to be enough to kind of tip the balance to really achieving the kind of change we need to see at the national level and how quickly that might be able to happen. And I guess I would echo, I was going to say something similar, which is if you look through history, we haven't seen kind of the really fundamental change without disruption. Right, so without kind of mass disruption and protest. So if we think back into the 1930s and the sit-down strikes and the massive strikes of unemployed workers and employed workers, or if we think to the 1960s, the civil rights marches and that. So I think we need to see more organizing and more, if we're going to see the kind of change at the national level, that we need to create the infrastructure for people to have these rights and have what's fair. And then the only other point I would add is I think it's really important for people who don't see themselves, presumably most of you in the room are interested in labor, right? That's why you came to this panel. But for people who are, interested in democracy or interested in climate change, to understand that organizing and workers having a voice and having power is critical to achieving those goals as well. And for the national political leaders to prioritize change that will create kind of long-term power for workers.
So I could keep this conversation going for like all afternoon, but let's open it up. We have a microphone. Oh, let me do the other CLE code while people are thinking of their questions. If anyone has a question, the second CLE code is Apple, like the fruit, not the company. So if people can just keep their questions, not the like this is a comment, more of a comment than a question, but like actually ask questions, that would be great.
Yeah,
Thank you all for being here. I'm Kyle Campbell. I'm an associate general counsel at AFSCME, and you've all talked a lot today about the ways that we can improve private sector organizing, utilizing either state and local or federal funding. But I'm curious if you have any ideas on ways that state and local governments can improve public sector organizing opportunities, building off of either the victories in places like Chicago or like kind of the block grant funding that states and municipalities have received from the IRA and related legislation.
Well, I can just say that in the Minnesota bill that I was talking about earlier, they did include reforms for state level employees. There's access requirements. I didn't write the bill, so I'm not that familiar with it, but I know that they made a lot of strides there in requirements, access to new employee orientation, lists being shared with the unions. I think it's every 120 days with employee addresses, names, email addresses that they can communicate with the workers on their work email as long as it's not related to a union election. So there were some things that they did in that Minnesota bill that will be signed by the governor if it hasn't already been.
I could just add also that a number of laws like that were passed in the wake of Janus trying to expand public employee union access to new employees. And the other thing that I would say in terms of state and local innovation is that, a number of states have granted collective bargaining rights to previously excluded public employees, like in Colorado, for example, and I think Nevada as well. There was some expansion, as well as creating public employee workplace safety and health laws. People might not know that OSHA, the Federal Occupational Safety and Health Act, does not cover public employees, and so states themselves can take that on and create those laws. And I think New Hampshire maybe did something recently in relation to public employee safety and health, or is poised to, but a number of states have taken that on as well. But it's a huge gap that they're not currently covered by the federal OSHA Act.
Professor Andreas, I also apologize if I butchered your last name.
You did it right.
Okay. You mentioned earlier about deference being a major issue, particularly for the NLRB, citing EPIC systems. I was wondering if you could talk a little bit more about that, and also whether the NFIB v. OSHA case that said that if a workplace hazard isn't exclusively a workplace hazard, it's not really regulatable under that act. If people in other sectors that are regulated by workers in other sectors that are regulated by OSHA are particularly concerned about that dicta.
So first, on the kind of spate of administrative law decisions or like threatened future decisions from the court that might harm workers' rights and weaken labor agencies. Deference is one, right? So to the extent the court seems to be moving to get rid of Chevron or to cut back on Chevron and essentially have courts defer less to administrative agencies' expertise, that could potentially be a real problem. I will say, like, courts haven't actually been all that good about deferring to the NLRB when the NLRB does kind of pro-labor when it interprets the statute in ways that are advantageous to workers. So how much that the formal change in doctrine will actually matter is the question. Maybe more important, though, is the development of the major questions doctrine and the idea that any time an agency is again, we don't know how broadly that decision is going to be interpreted, but assuming it kind of is interpreted broadly, the idea that any time an agency is regulating in such a way that involves major political and economic questions, which is pretty much everything related to workers, that the agency isn't going to get deference, or even worse than that, that the court is going to assume that the agency lacks the power is deeply problematic. And then the other kind of line of doctrine that's developing is the idea that that independent agencies actually might be unconstitutional, and so that could also be a real change. And then I can actually go on with multiple other like kind of threats that are percolating out there, like a broader understanding of compelled speech, so that would limit the ability of agencies, for example, to require employers to post statements of the law or to require employers to read statements that they've violated the law, right? So there's a whole bunch of ways in which if the chamber's constitutional interpretations are eventually embraced by conservative courts, the agency's power will be really eviscerated. I would maybe, I don't know if you can speak to the OSHA question. I don't know enough about the case to answer. It's a great question. Okay.
Hi, Nicole Sammy. You've all done a wonderful job of speaking about organizing opportunities and tactics and flagging concerns. But as we've seen with the Starbucks workers and the Amazon workers, all the momentum and excitement is limited if workers can't bargain a contract. So I was wondering if you could speak to the opportunities for bargaining contracts and any of your concerns on that.
I don't know. Do you want to talk about the Starbucks, or should I give a more general?
Yeah.
Okay. So this is kind of highlights the problem I started with, right? Which is there's a massive interest in organizing among workers in this country. There's been upsurge of organizing, but they're organizing under a legal regime that is deeply flawed and unfair. And so they have those Starbucks workers, won elections across the country, including in red states, right? And they have the right to organize. They have the right to bargain. Starbucks has an obligation under the law to bargain in good faith. It is just violating the law right and left. And even aside from it violating the law does not give the NLRB the power to impose a contract. So, there's basically the law is structured in such a way that if the Starbucks drags its feet, it can erode the momentum. So, what's the answer to that? Well, one is the NLRB is trying to pursue more aggressive remedies, injunctions, bargaining orders, which it has some power under the law that has largely been moribund for many years, and this general counsel is trying to kind of use more of the existing powers. The other is just more organizing and more pressure brought to bear to kind of force Starbucks to obey the law. The Senate recently held hearings to try to draw attention to the violations, but it just really highlights the problem, right? Which is workers are organizing under a deeply unfair regime, and we need to there needs to be enough organizing to change the conditions under which they're operating.
Yeah, that.
So we're just about at time. I guess what would be a good way to end would maybe be if each of you could just share like one sentence on what role lawyers and law students can play in supporting workers, worker organizing, and workers' rights. And just like super quick, like elevator pitch or soundbite, because we are just about at time.
I think it's training. I talked about it. Training workers about what their rights are.
So I think lawyers need to see themselves as part of the movement. They're also organizers. They're also activists. I have students who are that, right? And they're even when they're writing papers for my class, they're trying to use those papers to help, say, the Worker Center in Iowa City promulgate some kind of ordinance or something. So, yeah.
I would say we need lots of different kinds of lawyers in the fight. So yes, we need labor and employment lawyers for sure. We also need progressive immigration lawyers and tax lawyers and campaign finance lawyers. Lawyers that can make a contribution in all the domains that shape workers' lives. So that's what I would say.
I absolutely second everything that was said, and we'll just add to that antitrust, right? Knowing antitrust law, bankruptcy law, corporate law, right?
Yes.
Those are all fields that you can work in, and the key is, I think, if this is the kind of thing that's interesting to you, like being a lawyer in service of these movements for change, lots of different ways to do that.
And I would just add to that, to echo what Zephyr Teachout said in the first panel. She was, talking with great excitement about, like, there are all these opportunities in the USDA, like, go work for the USDA, and just that, like, government, too, can be a real ally and partner and brings real power that can be leveraged on the side of workers. So, there are so many different ways to play a part in relation to trying to improve workers' lives and help people exercise their collective power, that then again has, and I think just to close us out and sort of the democracy theme, you know, I think a lot of people who are progressive and who are concerned about all of the issues that like all of us here at this conference care about, a lot of people don't necessarily think of the union democracy connection and the fact that like, I think that that's very relevant, and if, you know, I think that's one takeaway that I think is really important, you know, all of us, I think, would really want people to take away is just the fact that, you know, unions are a really important player in our democratic process and in democratic participation. And the other piece that I would really want people to take away is just that, like, even though we're here in the nation's capital, that the federal government is not, like, everything that's important does not happen in DC, and that, you know, there are so many really interesting opportunities for improving people's lives and bringing about justice, you know, all throughout the country. So thank you everyone for coming. It was so great having you and being so attentive.